help us as we go through this bill, this new bill that will usher in a new regime. Help us to approach this from a point of the citizenry of Jamaica. Help us as we go through to have wisdom and understanding. Be with us, guide us as we do the work, and be with us at the end as we leave to go to our different places of abode. Be with us always. In Jesus' name we pray. All right. I have one apology for absence from Mr. Julian Robinson. I know other members are on the way. I touched bases with several of them and they said they were on the way, but we'll get started because we have a quorum. So we'll move right to the reading and confirmation of the minutes of the meeting held on Wednesday, July 10th, 2019. So are there any corrections, any additions, any edits? If not, we'll move for confirmation of the minutes. Senator Samuda? Okay. Second? Yeah, second. Okay. Thank you. Are there any matters arising from the minutes? All right. Doesn't seem as if there are any. So we will go right into the meat of the matter. For today, we'll be doing a clause by clause, and we will begin from the very beginning. So this is a bill entitled An Act to Protect the Privacy of Certain Data and for Connected Matters. So be it enacted by the Queen's Most Excellent Majesty by and with the advice and consent of the Senate and House of Representatives of Jamaica and by the authority of the same as follows. So I will, part one, preliminary, the short title. All right. Right, okay. Right. Okay. All right. So I'd like to ask members if they agree with the long title of the bill, which is an act to protect the privacy of certain data and for connected matters. Okay. Doesn't appear we have any dissent. We will be looking at this publication, which is a matrix of stakeholders' comments, research findings, and final commendations, Data Protection Act 2017. Looks like this with a jigsaw puzzle on the... And also we look at the parliamentary matrix as well. And... Right, so we have the parliamentary matrix. The matrix that was put together by Ministry of Science, Energy and Technology, and we have the bill itself. Short form. This is short form. No, this is the bill itself. Yeah. Okay. Okay. So we'll begin clause 1. Sorry. All right, since there are no objections to the long title, we'll move to part 1, preliminary, the short title, and commencement. Clause 1.1, this act may be cited as the Data Protection Act 2017 and shall come into operation on a day appointed by the minister by notice published in the Gazette. Clause 1.2, for the purposes of subsection 1, the minister may specify different dates for bringing this act into operation as regards different types of data specified in a notice made under that subsection. Yes. Anything?
Chair.
Okay. Yes.
Is it contemplated that that will be the approach?
Is it?
Is it contemplated that that will be the approach?
The clause by clause?
No, that the act will be brought into effect at different times as regards different types of data. The normal plain vanilla commencement provision just provides for the minister to bring it into effect by a notice published in the Gazette. But in this instance, and it's not unique to this, but it's I was just asking if this is what is anticipated, that there will be the act will be brought into effect at different times as regards different types of data, or is that not something that's been considered?
Okay. Ms. Murray?
If I might, through you, Chair, to the member, the intention really is to bring parts of the Act into operation. It speaks to types of data as well, but we would wish for the provisions in relation to the Office of the Information Commissioner to at least be brought into effect first, so that we'll have that body established while we go through the transition period that would be allowed, and then the rest of the legislation would come into effect at a later date. But we would need the office established and the work in relation to that office, well, staffing, and then for them to commence their work in working with the data controllers to have themselves prepared for the effective date, and that's when all the other provisions would come into effect. So at the very least, the provisions in relation to the Office of the Information Commissioner would have to come into effect first.
So this formulation needs to be adjusted then, because this doesn't focus on different parts of that being brought into it. Yeah, this is focused on different types of information. I don't know whether you want to have double flexibility, so you can bring different parts into effect at different times, and you can bring that act into effect as regards to different types of information at different times. I mean, that's pretty elaborate, but it may be useful. I don't know.
I thought this was just to facilitate, though, the transition period, and as Ms. Murray said, bringing into effect the Information Commissioner, having them staff.
That as formulated now, it doesn't allow that. So, given that that is what the ministry wants, then this clause 1.2 rather, would need to be adjusted to allow different parts of the act to be brought into effect at different times by different notices made by the minister. And I just added that if you also wanted to keep the flexibility that's provided by 1.2 in its current form, you could have that as well. So you could have a 1.2 A and B, for example, or however the drafter chooses to draft it. Yeah.
Yes, Chair, we could add some words at the end of subsection 1 of the clause to indicate that different dates may be provided for different parts of the Act.
All right, member, we accept those. We accept those changes. All right, we'll move on to
Hello.
Okay, do I have the agreement of the committee to accept those changes? To bring the act into force at different points in time? Agree? We have agreement? Right, but as amended by Member Golden. We have agreement? Yeah. Okay, we have agreement from the committee. We'll move on to interpretation and objects, clause 2(1), and we will move to the matrix, because that's where it begins, at least the ministry's matrix. And from the ministry's point of view, on further review of this section, as it relates to accessible records, it is recommended that the definition of accessible record be deleted from clause 2, and consequently the definitions of health record and educational record also be deleted.
So are those phrases, health record and educational record, that they're not used in the body of the bill?
Yes, they are.
Only
They are
in the
part of the
transitional provision?
No, they're used in the. They're part of an integral part of the definition of data.
Of what, sorry?
Data.
Data. Okay.
Yes. If you look at paragraph D of the definition of data, it includes information which does not fall within paragraph A, B, or C, but forms part of an accessible record. And then accessible record is also defined to include, well, to mean a health record or an educational record.
Right. So we could have just dispensed with accessible record and put health record and educational record in the data definition.
But this would be relocated to section 39, right?
No, Chair, we don't support that because, as I indicated, it forms an integral part of the definition of data and belongs in the substantive provision.
And that's a critical definition, data, I would think, in a data
Right.
protection.
Ms. Murray?
But just to make the point, though, in terms of simplifying it, given that accessible record means a health record and an educational record, which are separately defined, could we not in D, 1, just say forms part of, but forms part of a health record or an educational record, and just dispense with the extra definition, just to simplify it, unless it's used elsewhere.
Where the use of a single term would just simplify the drafting unless it make the provisions easier to read.
Yeah.
So, through your chair to the committee, we were recommending as a ministry the deletion of accessible record because, as the CPC would have indicated, the definition is used, the word or term accessible record is used in the definition of data, and it is used in conjunction with the current clause 39, which speaks about a transition period, an exemption period rather, for manual data. But we want to highlight also that the ministry is recommending that the current definition of data be deleted because what it is not a typical definition that we're accustomed to, which would say data is, can be the typical definition of data that we're used to, for example, one that would obtain in the Access to Information Act. What this definition does is simply to speak to how the data is processed as opposed to what data is. And we think that what is there in terms of processing manually or automatically can actually be captured in the definition of personal data, so that we'll do away with the entire definition for data, which would mean that the definition for accessible record would go, and the definition for health record would go, and the definition for educational record would go. So that is a proposal that we have from the ministry in terms of how to treat with accessible record, health record, data. Because if you look at the current definition of data, it says it means information which is being processed. So it's speaking about how the thing is done as opposed to what data actually is.
And you're saying that personal data would be a sufficient definition for the bill? You wouldn't need to define data separately?
Well, I wouldn't agree with that because personal data also uses the term data in that definition. So it wouldn't take you anywhere without a definition of data.
Sorry,
Chairman, if I
CPC,
may.
could you just repeat? You're saying that since personal data makes reference to data, we'd need to define what data is. Yeah.
Yes.
Of course, you also have the other option. When a term is not defined, it's just ordinary meaning of data. So that's the other option, where it's just left to the ordinary meaning. The only issue I would raise, though, is whether data is kind of considered a term of art, which I'm not sure about. And if it's not, then it's ordinary meaning, which means you use my preference, concise Oxford Dictionary.
In any of the very recent data protection bodies of law, that like the recent one from Europe and so on, do they define data?
No, Chair.
Okay.
Through you
We're
to
gonna
the
look at the
member,
research
Chair.
findings.
If
Yeah.
we take it to page 9 of the matrix from the ministry. So our comment here is that the current definition of data covers information whether stored manually or electronically and is more expansive than just information which is contained in the current definition of accessible record. The definition covers information that is already in the possession of the data controller, and such there is no need for any specific reference in the bill to retroactive application. That's with respect to our comment. But we note that, and we're recommending that the word data be deleted, and what we've seen from the research is that where data is defined, it's simply defined as covering all information of which, this particular one would be something from the UK, of which accessible record is only a type. But generally, when we look at the other jurisdictions, we don't see a definition per se for data, but rather a definition for personal data and a definition for sensitive personal data. And then within the definition of personal data, you would speak to the fact that that personal data can be something that is automatically or manually, data which is processed either automatically or manually.
Could we go to the actual meaning that's here for data, if that would help in terms of the understanding on page 2 and then come back? Data means information which is being processed by means of equipment operating automatically in response to instructions given for that purpose. Is recorded with the intention that it should be processed by means of equipment operating automatically. Is recorded as part of a relevant filing system or with the intention that it should form part of a relevant filing system, or does not fall within paragraph A, B, or C, but forms part of an accessible record or is recorded information held by a public authority.
In your comment in the big book on page 9 going over to 10, where you say, however, as this distinction is still important, it is recommended that the concept still needs to be reflected in the bill. What distinction are you talking about?
The distinction we're referring to there is the fact that it's electronic or in electronic or in manual form, which effectively is what the definition that is which was currently read speaks to, something that is data which is in electronic or manual form. And so we still think that that distinction is important, because we're saying the data protection bill should apply to data which is processed electronically or manually, or is contained in electronic or manual form. But we don't think we need the definition of data to be able to say that. That can be included in the definition of personal data. So if you turn with us to one moment, please.
Where would that distinction be addressed if you delete the definition of data and focus on the personal data definition, which doesn't make that distinction currently? Page 6 of the bill.
And I'll, of course, revert to the CPC for this, but it could be either in means data, which is processed data in, looking at the definition of personal data, it could be data in electronic or manual form relating to. So you could have it there. Additionally, you could have it in the definition of processing, which is also there, and it could read in relation to information or data which is processed in electronic or manual form. So what we're saying is that the current definition here simply focuses on the form in which the data is contained and not really defining data per se. And that can be captured, that is, the form in which it is contained can be captured in other definitions within the current bill.
Well, I think the purpose of setting out the definition like that would be to delimit the provision so that it does not capture everybody in Jamaica, because everybody would have access or in their possession some data of some kind relating to another individual. So I think the purpose of having a definition in that form is to limit the provision so that its application does not include everyone.
Lost because I can't understand the damage that defining data would create when I read it in conjunction with the other definitions. So you have data, you have personal data, you have sensitive personal data, but in the explanation which I'm getting, I'm not sure exactly what is the difference which is being expressed and why there's a concern about the definition of data remaining as it is.
So the recommendation for us is that data be deleted because we don't think that it adds anything of value to the bill as it is now. But the concept that data can be contained, the form in which you can have data is manual and or electronic, is important, and we feel that that can be captured in other definitions within the bill, whether in the definition of processing or in the definition of personal data. The bill is not speaking about data at large. What the bill is focusing on is what we define as personal data and or sensitive personal data. So data isn't at large, it's not anything. The bill is about data protection, personal data protection, and sensitive personal data protection. So personally, we don't see a value in keeping the definition of data as it is, and because nobody else defines data in their legislation, other than the UK and the UK, right? Other than the UK, which is where we've modeled our legislation, then we're saying it could go, but still keep the concept that data can be contained in a form that is either electronic or manual within some other definition in the bill. And for that purpose, we're saying we could use processing as one option, the definition of processing and or the definition of personal data.
CPC, your point was that the definition of data was to circumscribe the scope of what that word meant in the bill so as to exclude things that the bill really shouldn't be focused on at all. And I think the point being made by Ms. Murray is that the personal data definition could achieve that without having to define data itself.
Ms. Murray.
Sorry, if I may though, so there would be an issue because I'm looking at the bill. There are parts of the bill that just use the word data. So that means then, if we were deciding to delete the definition of data, remember I said the other option is when you don't define a term, it's ordinary meaning. But as has been pointed out, not just by CPC grant, but also CTD, that's not the intention to use ordinary meaning. So for instance, on page 10 of the bill where you see in the clause 4, 5C, 4, 5B, where it just talks about protection of data. If data is not defined, it would mean data in its wide context, which is not the intention. So it probably would mean if you delete the definition of data, then you would have to insert throughout the bill personal data or personal sensitive data, which is, I think, the issue that TPC would be running away from, because sometimes they don't like to do all of that. This is why you may just define a term and it's easy for you to then use that definition throughout.
No, well, even further, using the term personal data doesn't really help you because the term data would still be used and it leaves it open as to what you mean by that. I don't know if it is that you would consider then maybe just talking about personal information about a person and leaving it and then setting out what you mean by personal information, and then you can refer to personal information and avoid the use of the word data altogether.
I don't know, but the word data is all over the bill.
Ms. Murray's point is that data is wide and all-encompassing, which I think you accept. But the scope of the bill is to deal with regulating how personal data is used, right? So if data was, but the way that the data is defined here is to limit the meaning of data.
I don't want it limited because
yeah. But why? If personal.
No, but a definition of personal data that refers to data doesn't help you. So you would still need to tell me what you mean by data if it is not the ordinary meaning that you intend to capture.
So, Ms. Grant, are you saying that the meaning here, the meaning of data here, should remain, right? Should remain.
Can I ask it another way then? Let me ask the question another way. What's the harm leaving data in the way it is now? Which I think is what member Scott Motley was, where she was going as well. Because if there is no great harm, then perhaps this may be the unhappy medium.
It's certainly, I mean, it's being advocated for by the ministry that we remove the definition of data. Now, what I would say is that it adds to the complexity of the bill to have a concept defined in a special way like this, like data, in a way that's narrower than its normal meaning, and then you have to superimpose onto that another definition. So you have a defined term that's then used in another defined term, personal data, which further limits what that thing means. So, and I think her point, Ms. Murray's point, was that what we're really regulating is personal data. So if the word data is just given its ordinary meaning or has a wide meaning, it doesn't really affect anything, because what the bill should be focusing on and using is the terms personal data and sensitive personal data. So if you've identified, for example, a clause which only refers to data, that maybe should be fixed, because that's not what this bill is trying to regulate.
So the name of the bill, Data Protection Act, it's really a Personal Data Protection Act?
There are other instances as well where you have data processor. Should it be personal data processor? Yeah.
So if you change the naming of a bill, that would solve the problem.
Okay, so what is it that we are agreeing on? So CPC and MSET, what is it that, that we're agreeing
so
on?
So Chair, based on what was being discussed, we are proposing in the definition of personal data, we would remove the reference to the word data in the body of the definition. So it would read along the lines, personal data means information relating to a living individual who can be identified, A, from the information, or B, from the information and other information in the possession of or likely to come into the possession of a data controller. So we have data, we use information. As the SG indicated, elsewhere where we have the word data without the word personal in front of it, we would make a modification to include personal.
So does that mean wherever we see data controller or other such term, we put personal in front of it?
We need to adjust terms like data controller. That's a bit tedious. No, we can live with it. Yeah. Well, it would. I think data controller would be a defined term, wouldn't it? Which would make reference to personal data, presumably. Yes, it already does. It says, it means who determines for the purposes for which and the manner in which personal data are used. So, yeah.
All right, so the recommendation is to change the definition of personal data from wherever data, the word data is in that definition, to change it to information. And it looks like it appears twice in it. So personal data would read, personal data means that data relating to a living individual who can be identified from the information.
Personal data means information relating to a living individual who can be identified from the information or from that information and other information in the possession. Well, the CPC will sort that out. Yeah. One question though, and this is a slightly different point but relates to the same definition. I noticed that it's limited, personal data is limited to living individuals. So if you have a deceased relative, the information about them is unprotected.
So, as it is now, the bill is applicable to living persons. During our consultations, subsequent to the committee sitting and considering this bill, we did receive some comments from the Ministry of Health, and their concern was that the bill, they had a concern with the fact that the bill was only applicable to living individuals as well, and wanted the protection to be extended to deceased persons, of course, for medical purposes, in that the medical information of the deceased would be protected for a time or a period after their passing. So that concern wasn't raised by any other stakeholder that the committee would have heard from. That was something that was received by the ministry separately from the Ministry of Health. We haven't really formed a position around it. The policy intent is as it was reflected here for living individuals, but it's something that the committee can think about. What we have thought through in terms of how this would work is that if you continue to protect, the question is, what are you protecting? And why would you need to protect the data of a deceased? How would that person be harmed by the disclosure? So there are persons who feel that it is important that the information continue to be protected. So for example, for the medical purposes, if the person died from HIV or AIDS or whatever it is, and they didn't want their family to know about it, then that would continue to be sealed. On the flip side, our argument is, yes, but what will happen is that the living person can be affected by the fact that they can't access the personal data of the deceased, because they won't know if, say for example, the person died from AIDS. They couldn't access that information at all, and they may be continuing to live in ignorance, not knowing what is happening if they never ever get tested. So our concern is that there are pros and cons to extending the protection to persons
that
who
wouldn't be an exception. That if the sealing of the information could adversely affect the health of an individual or the welfare of the public health issues, that's not an exception.
So that's the point. You could make an exception if the committee decides to go in that general direction. You could also set a term, 10 years, 15 years. I mean, some jurisdictions, I think Canada goes for a very long time, up to 50, which is just a lot, we think. But it's something that the committee could consider, and we'll do some further research on how it is treated. But the issue didn't arise at all from other stakeholders and would have only been raised by the Ministry of Health.
Well, I'm sorry I'm raising it now, but I am. And I'm not even so focused on medical records. I'm just thinking of somebody's spouse dies, and all of a sudden all their personal information is now no longer protected. So somebody can be saying things about them, about their personal life, about their proclivities, whatever it may be. Is that the case? I mean, I wouldn't think that's, your parents die or your husband or wife dies, and all of a sudden all information, all their private information ceases to be protected. You as their next of kin should have a right to protect their privacy, I would have thought.
If I may, Chairman? Thanks. So under the Access to Information Act, Section 22, could be 23, Personal Affairs Provision. All records, all official documents held by public authorities can be released under an application under the Access to Information Act, but there are exemptions. One of the exemptions is in relation to personal information, and it excludes the release of personal information that relates to whether a living or a deceased person. So that's the first thing, that we have that provision in our laws, and we recognize that you treat deceased persons' information as sensitive personal data. We've also done a little research in relation to privacy and the constitutional right to privacy. And there is some learning in different jurisdictions about protecting and it being a right to privacy that continues even in death. I know that the chambers did some research as well on this issue, but only in a limited context in relation to health, and I think had advised the ministry to liaise with the Ministry of Health, but I think it's actually a wider issue. It's not just linked to health, and I think especially when we look at our constitutional protection to privacy and recognize that our constitutional right to privacy, I always say we have taken it a little further and a little higher, and it's more expansive than most other jurisdictions. And noting that there is case law from other jurisdictions indicating that this right to privacy can continue into death, we should really perhaps look at this a little more carefully. I don't know if perhaps the chambers could be given the week. I think you're meeting next week. So, I mean, this is something we could look at a little more if we got the week to look at it. I also wanted to just make a comment about the decision of the committee in relation to personal data, and just ask as well that, well, I'm assuming the committee took a decision on personal data and how to treat with this whole definition of data, and just ask that you square bracket it, because I think when we go through the bill, we really should just very keenly and carefully look at how we use data, look to see if it fits with just using personal data throughout. So I know you may have taken a decision, but I'm just asking you to just sort of square bracket that decision so that when we go through, we can make sure that it's a seamless fit. Just a suggestion.
That would be prudent, but another question, would you have wanted the words whether electronically or whether stored electronically or manually, to be incorporated into the personal data definition, or rather than put it that way, to say only if it is stored electronically or manually is it personal data? Is that the correct approach, that from the ministry's point of view, that we're trying to limit what this is dealing with, this bill is dealing with, to information stored electronically or manually, or is that a limiting factor, or is that an expansive factor?
For us, it's more of an expansive factor,
Okay.
because we're saying the fact that the data is manual, the personal data, let me just use personal data now.
Yeah.
The fact that the personal data is manual doesn't exclude it from the legislation.
Right.
We're talking about personal data that is in electronic or manual,
By
meaning
manual,
on a
you
file.
mean not electronic.
Right.
Yeah.
So for those...
So a book is manual in your book.
That's right.
Okay.
A file or hundreds and thousands of files would be captured under this.
All right. I take the AGC's recommendation to square bracket personal data, and for them to be given some time to look at the living individual versus the deceased persons, as to what rights a deceased person would have in terms of personal data. All right. So we'll move on to, the committee accepts that, given the CPC, until the next sitting to look at personal data.
Yeah, and in terms of this concept of manual, what you're really saying, whether stored electronically or not, that's what you really, yeah. Because the idea of manually stored, you're using that to mean anything that's not in an electronic form. I see.
Isn't that because of how Jamaica is still set up? We have still a lot of information that is stored manually and not digitally. That's the reason, correct? Or
Yes, I mean, if you just consider the HR files that would be contained in any organization, whether public or private, most of those probably would be most of those would be manual files, especially public SG saying.
Sorry, I'm going back to another point. I think I just need to clarify. I hope I didn't give the wrong impression. It's not that a deceased person has a right to privacy, but the information linked to that deceased person, say a relative, can have that a certain kind of interest where the privacy interest still persists, but it's just so it's not the deceased person right to privacy, but the information is still protected. And so the privacy right, I guess, would be more linked to the person who's alive, but is linked to that deceased person in whatever form. So sometimes we've seen it in relationship.
It's not like a property right that is inherited and can be
No.
enforced, but
No,
it's more like
I haven't
a
seen
right
that.
that a person has a certain relationship with the deceased person is regarded as having themselves some rights to protect the privacy of that individual.
Yes.
In terms of their kind of honor.
That's how we've seen it. So you can see that in a way it follows the information. The right to privacy sort of follows the information. I may be saying it in a very roundabout way, but so that information, so my certain things that were personal to me and I have died, because my son can now claim and say, well, that information about me still should not be released when I'm dead.
All right.
Suppose, Chair and members, based on what the SG has said, the interest is not so much in the dead, but in the living. And how revealing that deceased person's personal information would affect a living individual. Right. So if we're clear that that is what we want to be researching, then we could do the research around that.
And it's very much the impact on the living of disclosing the privacies of the dead. Yeah.
Exactly.
And which living persons have an interest in that protection.
That's right.
Yeah.
All right. Go ahead.
I'm sorry. So we had done some research based on other jurisdictions that applied data protection legislation to the deceased. And for example, in France, we are aware that a person prior to dying can determine by way of will how you want your data to be treated, or there's a regime that is established similar to intestacy in terms of a hierarchy of relatives who, if the deceased died intestate, could determine how they wanted that particular person's right to be handled. Other jurisdictions give the power to the minister to apply data protection legislation to deceased persons for a number of years, and the minister can extend by order the number of years that you would want. But it depends on the policy rationale behind why we would want it to apply to deceased persons.
Okay, so is it that the AG's chamber doesn't yet know which of those options they'd want, and so you need the time to look at it?
That wouldn't be us, no. That would be more no. And I see Member Golden laughing because we always say, you know, we're legal advisors. And yes, there is a little mix of policy, but we can put forward some options, but at the end of the day, and especially since it's now before the committee could look at it and determine what they think would be a good option.
The spectrum seems to be, in France, they treat the data of the individual almost as property, which can be inherited, and then there's a ranking as to who has the best claim after death to make decisions around it and all of that, as opposed to being something which persons close to the deceased person may have a personal interest in protecting the honor of that individual by ensuring that their data, if it is the private nature of it, is not abused, and that's not so much a property right, but some other kind of recognition in law of their interest in that. Yeah.
All right, so just to wrap up here again, the AGC has asked for time to look at the personal data definition and to also look at issues surrounding deceased person and their private data, as they will come back to us with options as to how to deal with that. So is that a correct statement of what's desired, AGC? I'm just saying the AGC has asked for some time, at least until we come back to the next sitting, to look at personal data and also issues surrounding the personal data of deceased persons, and you will lay out some options for the committee to consider.
No, not really in relation to personal data. I was suggesting that the committee go through the bill because of the way in which data is used throughout the bill. So you would have taken a decision about how you want to amend personal data and then delete the definition of data. And I'm just saying, I think we have to apply a little caution there because we're not sure, for instance, what we will meet in clause 30. And I think in relation to personal data, I would prefer if that decision in relation to whether you delete data or not, how we amend personal data, if the final decision is taken when we have almost concluded going through. But the AGC will do a sort of matrix and give you some options in relation to how you treat with the information of a person who has died.
All right, we take the caution. So we can move on to biometric data. In the same clause, we had some comments from stakeholders regarding biometric data as well. I know. Okay, I'm reminded that we did not agree, the committee didn't agree whether accessible records should be deleted, but my understanding is because we haven't fully dealt with data or personal data, right, when we do, it would take into account accessible records. Yeah, right. All right. So we'll move on to biometric data. Or from the ministry, they comment that the definition for biometric data is limited, may be a valid comment. And in this regard, it is recommended that the definition of biometric data be amended as follows. So I'm reading page 2 of the matrix. Biometric data means any information relating to the physical, psychological, or behavioral characteristics of an individual which allows his unique identification, such as a photograph or other facial image, signature, fingerprint, toe print, palm print, footprint, vein pattern, iris scan, retina scan, blood type, height, or eye color, or such other attributes of the individual. So this will be the data which will be protected as sensitive data and requiring a higher level of scrutiny.
And genetic information is excluded. For what reason?
To be protected.
It's also defined.
It's not. So
Included
it's
in
not biometric data. It's biological information which can be used to identify people. So
it needs to be protected.
Yeah. I'm just asking why it's not subsumed in it, you know.
Ms. Murray, do we have it elsewhere?
I know we've defined it separately, and I think the other jurisdiction defined them separately as well. In this bill, it's genetic is defined, well, it's given the meaning that is now in the DNA Evidence Act.
Yeah, so but I'm just asking if biometric information, biometric data ought not to include it. I'm not saying you shouldn't define what genetic data is. That's useful, but I'm just wondering if the purpose of this definition of biometric data is to define different biological sources of information that can be used to identify people. Why would genetic data not be part of that?
Mr. Aldridge, what?
I'm saying it depends on how it's used. I'm a real big believer. I'm a big believer in doing definitions last, because you only understand the definition based on the context in which it is used. Oh, so it is in sensitive personal data on page 8 of the bill, and it's in the definition, paragraph A, it says genetic data or biometric data. So it splits it out in paragraph A. So that would be the reason you would have it split, the two terms defined.
If one included the other, you would just say biometric. You just say biometric data because it would include. It just seemed to me, in principle, that it ought to be part of it because of the purpose of the biometric data definition is to identify all these different forms of biological data that can be used to identify people. But it's not a big deal if you want to keep it separate.
For clarity, I just want to understand exactly what is meant by behavioral characteristics, because I see, maybe Joaquim can help us. I want to find out what is meant by behavioral characteristics, because from my very cursory reading, it seems very different from the examples that you have given here. So for clarity, could you just explain to us what really is the thinking? Is it that you just took it out of what obtains in the EU, but what exactly does it mean? You read online and they tell you what it means, you know. It sounds to me like if you have a behavior like you're a serial rapist or you have a certain propensity, that's what I deemed to be behavioral characteristics, but that is in conflict with the examples that you have presented here.
I have a similar concern, and I noticed that it was said that it was used extensively by EU members and also South Africa, Gabon, Austria, and Bermuda. But I try to wrap my head around how you would capture behavioral characteristics as well. And I would appreciate the clarity also.
I take it that the committee is saying that behavioral characteristics is not, well, the examples that are given don't align with the definition of behavioral characteristics. That should be a separate attribute. Mm-hmm.
Understand what is meant or what is hoped to be captured, then it helps us to understand whether these examples fit
Fall
in.
in that,
But
okay.
from our reading, they do not seem to fit into what it's deemed to be the term.
Behavioral characteristics. Ms. Murray, any? All right, Ms. MSET is asking to come back to this. All right, you're asking for a little bit of time on this one. Okay, they're doing a little bit of research there. Still on this biometric data, we had a concern from Hartmut Fatah that the word oh, hold on, sorry. Oh, that the definition should be modified to remove the phrase as may be prescribed. What's the committee's of that?
I think the recommendation went beyond that. That recommendation was by Hartmut Fatah, who suggested that we remove as may be prescribed. But when I read the recommendation that came from the ministry, it was far more expansive. It expanded the definition of biometric data to include things like physiological and behavioral characteristics, which the question is, does it take it into too broad a framework? Was that what was really intended?
From the ministry's perspective?
Yeah, but it was a ministry who actually said physiological or behavioral.
I mean, I don't think a behavioral characteristic is a biometric thing. You know, somebody who constantly scratches their ear or something, is that, in what sense is that? And how can that be a safe way to identify someone? I don't know.
Okay. Ms. Murray still needs some time?
There are two options on the table, I think, Chair and members. We could go back and look at how that behavioral characteristics is defined and what they treat with, or alternatively, we can just take the decision to just kind of exclude it if members just think it's generally wide.
Before you exclude, just a question, would behavioral characteristics be associated, let's say, someone with autism? So an individual with autism would manifest particular behavior which is associated with their physiological condition. I'm trying to figure out if that was what you were trying. So if you're autistic, you have a particular type of behavior which would define you and if persons access that data, they could recognize your medical condition by if they have knowledge of what autism looks like. So I'm wondering if that is the reason why that was included. I suspect that that would need to be protected if that is the objective of that in there.
Yeah, I mean,
And I think what we're saying is
none
that
of the list here, though, that you have in your thing, you follow the general comment of behavior, you call it behavioral and physiological and physical, and then you have a long list of things: fingerprint, palm print, footprint. None of it is behavioral, you know. So it makes you wonder whether there aren't any examples that you'd want to.
I think the first thing that we need is clarity as to what it actually means or is intended to mean, and then from there we can make a determination.
What it seems, Chair, is that we're all suffering from perhaps not being au fait with what seems to be term of art. Because if you even quickly Google it, you see there's behavioral biometrics, which relates to a field of study related to the measure of uniquely identifying and measurable patterns in human activities. Could very well be what was said a while ago relating to autism, but it also seems to be a term which contrasts with physical biometrics. So a contrast between behavioral and physical, which involves innate human characteristics such as fingerprints or iris prints. So perhaps it is us who are suffering from not understanding what's a term of art.
Chair, I'm looking at a definition here that says behavioral characteristics are based on behavior of the person, voice, signature, gait, etc. So what is going to be very critical here is what we mean and what we intend to achieve, and to craft a definition, of course, or use the terms of reference that is going to evidence exactly what we want to achieve.
To add to that, it refers to even the behavioral biometrics being used to secure authentication in financial institutions, businesses, government facilities. So it may very well be relating, Chair, to what we have even on our phones now, voice ID and signature analysis and cognitive biometrics. So it's something which we have to be clear on. Is it that, or is it the other suggestion that has been made? What does it mean? Because it's two very distinct things.
Chair, to support Senator Charles's position, there is a development in modern technology that can identify you based on your behavioral characteristics, your gait, and so on. And we know, based on research, that a lot of companies are using this sort of technology as a different level of identification and verification internationally. So I would suspect that in us defining it, we be a bit prospective in looking at where the world of technology is going and using people's quote-unquote behavioral characteristics to define them, because I think that's where the world is going now.
So what we'll do, Chair, committee members, is we'll come back on this, but I think the signal that we're sending is that across the jurisdictions, that's a direction that everyone seems to be going in relation to broadening the definition of what is biometric data to cover the things, both things I think that both member Morgan and member Charles would have mentioned.
I think a good place through the chair that you may want to look at is the Chinese approach in terms of how they are developing a significant, I don't want to use the word surveillance, monitoring system, and other countries like Israel, who are developing a significant monitoring system that does not get your fingerprint or your vein pattern, but how you walk, how you move your head, and so on. And I think a lot of other countries throughout the world and companies are looking at that. I think majority of their technology comes out of the United States of America. So I think we have to be very careful in not being too restrictive.
At the same time, we have to take into account our Charter of Rights and our privacy.
All right, so MSET is supposed to take a look at this and come back with a definition of behavioral characteristics, and also to take a look at genetic data as to why it's not included in biometric data. It would seem to be a subset of that and to be included as data to be protected. All right. We will move on to just looking at the page where we need to go to next. Clause 2(1). Clause 2(1), consent. Okay, from MSET, the Data Protection Bill would benefit from a more expansive but precise definition of consent. It is recommended that the following definition of consent replace the existing definition in the bill. And consent is where? And consent, we're still on page 1. Consent means any manifestation of informed, specific, unequivocal, freely given expression of will by which the data subject accepts that his personal data be processed, and includes any such expression of consent given by A, the legal personal representatives of the data subject, B, an individual to whom the data subject delegates the right to give or withhold consent to the processing, or C, in the case of a minor, a parent or legal guardian of the minor. Does the committee accept that new definition?
Question to the chair. Oh, I read it. It's fine. It's fine. Sorry.
Chair, just can I ask the esteemed council, are we following any one jurisdiction per se? I mean, I see a number of different jurisdictions here. But why I ask is there is usually a challenge, when specific things are pulled from different sources, and that challenge occurs usually when you're treating with the substantive interpretation of particular clauses later on. So I just ask, not that it is not an accepted process, but what's the primary base for these definitions for us?
Well, At the time when we were considering and developing the bill and issuing the drafting instructions, we would have utilized a lot of what the EU was doing, because I think members might, the EU and well, not their GDPR, it wouldn't have been the GDPR then, but their data protection directives to inform the direction in which we're going. What we have found generally is that in relation to a data protection regime, it is the EU that has the standard. And most legislation, for other jurisdictions, model in some way, shape, or form what the EU has set as a model, because they're really the front runners in relation to data protection regime. I mean, the US doesn't have one, and everybody else follows from that. So what you'll see here, or the actual bill itself that is before you, would have been modeled off the UK, which would have been a part of the EU then.
And I'm assuming that our bill and whatever sections we have modeled are modeled off the most current, the amended. Because you see, one of the differences between us and other jurisdictions is the frequency with which we amend our bills.
Admittedly, member, this bill was tabled before the UK would have amended their Data Protection Act in keeping with the GDPR.
Yes.
So all the EU states would have amended their legislation, national legislation, to give effect to the GDPR. And this was tabled before then. So what we would have been...
What year was that?
The GDPR?
Yes.
The 2018, May 2018.
Okay.
And this would have been tabled ahead of that time. So we would have been using a 1998 UK
1998?
Act, as well as the existing EU directives on data protection to inform this when we were developing it and before it was.
So would it be helpful? Is it?
So we would have also looked at the GDPR, because that would have been in train at the time. But what we find ourselves, I think, in a kind of precarious position, because the EU would have been maybe 15, 20 years at data protection, generally as a regime and practicing data protection. And we would have been utilizing what they would have been using, and now they're going into, I would call, version 2.0, which they now have to tease out with their new rights and so on. So what we would have done is to kind of look at and say, okay, well, some of these things remain consistent. They're learning, there's jurisprudence that would have developed around these things, and we can use them, and we can continue to use them. Some of them haven't changed. Most of what has been done is really to introduce new rights. And even in regard to some of the recommendations that would have come in from stakeholders, we, I suppose the ministry would be cautioning against adopting them too quickly, because we're just not there generally as it relates to the culture of data protection, much less to introduce new rights that we're not accustomed to and how we're going to treat with them. So model generally of the EU and the direction that they would have been going. And in doing the review based on the stakeholders' comments, we would have been looking back at the GDPR. You'd have seen a lot of reference to the GDPR as well, and looking back at the 2018 UK legislation, they would have updated that and deleted some things. So generally trying to keep it consistent. For another reason too, in that we have a trade agreement, for example, with the EU. And one of the things that they require within their GDPR is that you don't transfer to jurisdictions that don't maintain an adequate level of protection. So we can't be too far behind or have concepts that are too varied and wide when compared to theirs, because then you might be found to be a country that does not maintain an adequate level of protection for data. So so that's what we're balancing. Trading partners, who you tend to. So those are the things that you're looking at. And of course, where we can find the jurisprudence to support when our bill becomes a law and people start to sue. Maybe not.
Okay, thank you, Ms. Murray. There were if you look at the stakeholders' comments, there were many, but I think in the revised definition, some of those concerns were addressed. There was a concern about consent given by a minor. Ministry is of the opinion that that is adequately addressed in this, well, in the previous definition as well as the proposed new definition. All right, I would put the new definition of consent to the committee. Consent means any manifestation of informed, specific, unequivocal, freely given expression of will by which the data subject accepts that his personal data be processed. We agree. Accepted. The committee accepts. All right. So the committee accepts the new definition of consent.
Chair, if I may though, I'm just wondering if there's anything further that needs to be said in relation to the use of the term informed and what is contemplated by informed consent there.
You mean that you know what you're consenting to? Informed. No. Am I wrong?
Give you an example then. So under the DNA Evidence Act, informed consent is done in a context and it's explained. So for instance, there is a difference with, say, a suspect and how that suspect can give consent compared to, so the informed and whether a person, for instance, has any sort of disability. So informed and how you deal with children. So informed consent can mean different things to different persons. Rather than leave it to, when you just say informed consent.
It might have more really requirements than the normal consent? Informed consent?
So it does suggest, if you put a word before the consent, it suggests that there is something else with it. And so what we did in DNA Evidence Act was to explain what it means.
My understanding, and correct me if I'm wrong, consensual requires you to have some information, right? So, but I do appreciate what you're saying. I think every consent would have to be informed, but if it is spelled out, it could. It's
one thing if you just
could direct
use
to
consent,
something specific.
Right. If it's just one thing if you just say someone consents, then it's ordinary understanding of what you mean by consent. When you now say informed consent, it
no,
kind
but if you consent and don't know what you're consenting to, have you consented? If you come to me and say, listen, sign this for me, Minister, I don't know what I'm consenting to. Have you consented?
Which is why perhaps they wanted to talk about informed consent, but informed consent is not a term of art, which is why in other legislation I know that we have explained what exactly we mean by that.
If you can help me, perhaps if you could share with us the definition that you have used. Is it the DNA Act you reference?
It's used, so there are several provisions that I can look it up now, yes. But it's not just that one small concise definition, right. But I'll look.
But essentially though, you're saying that it goes beyond just saying, here's a paper and you're giving custody to Mary Sue. It goes beyond that, and it speaks about the consequences and the effects. Is that what you're saying?
It kind of goes into the process that's required to get valid consent to take somebody's DNA, depending on who they are and their condition. So for children, I'm not sure if it defines informed in a particular way, but it does give a process that different vulnerable groups need to.
Yeah. I have scribbled on my bill here a definition of informed, which I think might have been taken from the explanatory notes from the UK. Which states that informed with reference to any consent or agreement means that at the time in question, the data subject is informed about the purpose for which the data will be used and the class of persons to whom it may be transferred.
Okay. We accept? Mhm.
I mean, when you read it in context, I hear you, and I think it's a point that we need to look on in relation to inform. When you read it in context of the remainder, right, by which the data subject accepts that his personal data, we should even be that there, but that his personal data be processed and includes any such expression of consent given by A, B, C. Is there still a difficulty?
Might just add the processed here would be linked to the definition of process in the currently in the Act, which would include the collection, the storage, the transfer, etc., the full gamut, the destruction, and so on.
All right. So the committee accepts the new definition of consent.
Subject to the AGs coming back to us. I think that might be useful.
No, I found it in DNA evidence. So it was informed consent was defined as set out in section 14 of that act. And it's pretty long, but I can read 14.1. Subject to subsection 2 in this act, informed consent means A, in the case of an adult who is not a protected person, the consent in writing of the adult. B, in the case of a protected person, 1, the consent in writing of a parent, guardian, or adult relative of the protected person, or 2, an order of the court under section 22 authorizing the taking of a sample. So it's really a process, and the process was different for different people. And then so it went on. I mean, what CPC Grant said perhaps could at least help, and I think that could be considered by the committee, since those were coming from explanatory notes from the GDPR. So I wouldn't necessarily have to go into the kind of detail, because that was done for a very specific reason. But I don't know that you need all of that for this bill.
Informed with reference to any consent or agreement means that at the time in question, the data subject is informed about the purpose for which the data will be used and the class of persons to whom it may be transferred.
So we accept subject
We were
to
having a little
subject
conversation here. Mm-hmm. The concern, I'm sorry, our apologies. Right. So I'm suggesting that it be linked to process, because the definition, which was just read by the CPC, focuses on purpose of use and transfer of the data to someone else. But when we look at the definition of processing, if you look at your bill, it covers a wider gamut of things, and this is page 6 of the bill. So it talks about how the data is organized, adapted, altered, retrieved, consulted, used, and at C, disclosing the information, which is effectively the transferring or transmitting or disseminating or making it available to someone else. So I think the concern I have is if we limit it to just those two things, purpose and transfer, that might be a little bit limiting. It might be that the data controller should advise as to the processing or how the data will be processed, because then you do from start to end. This is how I'm collecting it here and I'm going to destroy it here, and I'm told about the entire process. So my big recommendation is, a modified version of what the CPC would have mentioned in terms of how to define what is informed consent. So it's an expanded version of that, not right. So it would be informed.
Yeah, so we could tweak it along the lines to say that it would be that at the time in question, the data subject is informed about how the data will be processed, and that would link it back to the definition of processing.
All right, so this new expanded
call it definitions chase.
definition.
You have to go from one defined term to another to understand what the heck it really means.
All right, so I take it that the committee accepts the new definition of consent with the modifications that the CPC has explained that it would add to this. Right? Agreed? No dissent. All right, let's move to data controller, still on clause 2.1. There's only one comment there from the JBA, but in terms of the ministry, our comments are that the bill is clear, that its applicability is, and this is page 10 in the matrix. The bill is clear that its applicability is limited to personal and sensitive personal data, and the current definition of data controller already makes reference to same. No other data is contemplated by the bill. As such, no further clarification is recommended. This is a data controller means any person or public authority. Huh? Well, yeah, we did data already. Remember, they're supposed to come back to us next week, yeah. So we're on to data controller now. And a data controller means any person or public authority who either alone or jointly or in common with other persons determines the purposes for which and the manner in which any personal data are or are to be processed, and where the personal data are processed only for purposes which they are required under any enactment to be processed. The person on whom the obligation to process the data is imposed by or under that enactment is for the purposes of this act a data controller. No change. Committee accepts. No change. All right, we move on to data subject. And I'm a data subject, you're a data subject. All of us are data subjects. So with regards to data subject, we had just one comment that the word living should be inserted before the word named. And the ministry is saying it's not necessary to specify living, looking at page 11 of the matrix. In the definition of data subject, since the definition of personal data, there is already a reference to a living individual. And a data subject is an individual who is the subject of personal data, so no change is recommended.
We had a discussion about that earlier as to whether that really is the correct approach.
The living,
to
the
limit
living versus
the protection
deceased,
to
yeah.
to only living persons that have their data protected, because some living people may have an interest in protecting the data of persons who are deceased.
Right.
Yeah.
So we won't
I
be.
think we could revisit
we
this
won't
when
be inserting living.
I think we could revisit it when the committee when they return, the technical team return to us next week, having considered the whole question of how you treat with a deceased.
Okay. All right.
Sure.
So
we
the
might
data
have missed
subject will be added to the list of items to come back with.
Right.
Yeah.
We might have missed it.
Which one?
Data processor, did we?
Yeah.
Okay, so we were okay. We accepted that.
Yeah,
okay,
it was accepted. All right. Still on clause 2.1, genetic data. The ministry is of the view, this is page 12, that there's no need to change the language to expressly link genetic or biometric data to an individual or medical record in order to encourage research and innovation, as the bill already describes these data as being linked to an individual. The definition of personal data, which includes sensitive personal data, means data relating to a living individual. Same issue there, living versus deceased, I'd imagine.
Chair, if I might, the comment here about not limiting and ensuring that there was that we encourage innovation and continued medical research. I just wanted to add and just highlight for the committee that innovation and continued medical research is allowed under clause 38, which speaks to research history and statistics. So there's nothing that prevents sensitive data, including medical data, from being used for purposes of research, provided that it's anonymized, right?
Okay. The committee agrees on the definition of genetic data. No dissent. We'll move on to health. We did. Oh, we didn't get there yet. Okay, sorry, I have to go back to page 10. We missed, or I missed, the clause 2.1 that includes data processor. The ministry has some observation. The observation from the research are adopted in relation to the insertion of the word authorized, and as such, no change is recommended. I think there was a recommendation from the stakeholders to, at least one stakeholder, to insert or include authorized before the word employee. So the ministry is recommending no change. Additionally, it is recommended that the definition of data processor be amended as follows. Data processor in relation to personal data means any person other than an employee of the data controller who processes the data on behalf of the data controller. It looks the same. No, I'm just saying this new definition looks the same as what's in the book.
It's not really new, it's just correcting how it's currently structured. Right, so it breaks it out into an A and a B, but it actually isn't.
It doesn't.
For data processor. You're at data processor?
Yeah, but data processor in the bill, unless I have to.
Right, so it's not substance but more form. Exactly. There's no A and B.
I'm sorry.
Yeah. So we're just suggesting how it would look as reworded. No, there's no change.
It's one sentence.
It's one sentence. Yeah.
All in favor?
Commas would be useful, though.
Yes.
All right, there's no dissent. We'll move on to health professional. All right. while you contemplate health professional, I'm told that there was not an explicit acceptance of genetic data, the definition of genetic data. Committee accepts the definition of genetic data. Page 12 of the matrix.
Chairman, I know I'm sorry, but I have to be the lone voice in the wind. Oh, it's not health professional. Apologies.
Yeah. No, we're requiring an explicit consent of the definition of genetic data. Yeah, okay. There's no dissent on genetic data. So now we're on health professional.
Lone voice in the wind here. I've noted the comment from the ministry on page 12 of the matrix, but I really have a difficulty with a private hospital being a health professional, or the NHF being a health professional, or a provider of ambulance. Well, I really have a problem with GH and I, how they are defined, because they're like institutions, entities, being a health professional. A health professional to me would be a individual. And I know we can define things for different ways and reasons in a bill. It just seems a little awkward to me.
So just to help the committee with respect to the references, no, not the lone voice in the wind, but with respect to where health professional is used. So it's currently used in the definition of health record. It's also used in clause 24, subclause 1I, paragraph I. So it's 24(1) and I. And this particular clause is linked to the first standard, which speaks to the processing of data fairly and lawfully. So what the first standard says is that data must be processed fairly and lawfully. And then clause 23 and clause 24, as it relates to sensitive personal data, provide some exceptions. So essentially it's saying that you can process data, personal data, without consent if it is necessary for medical purposes and is undertaken by a health professional. So in that context, the private hospital, and then it goes on to say that the health medical purposes is then defined later on at subclause 2, medical purpose, that's on page 39. Medical purpose is then defined as preventative medicine, medical diagnosis, medical research, a provision of care and treatment, and the management of healthcare services. So which is why some of those institutions rather than practitioners would have been added to the list of who a health professional is.
So the committee accepts the definition of health professional. Sure.
Can I hear the comment of the lone voice that was in the wind not so long ago as to whether that is sufficient now?
But they're handling personal data, so they should be included.
It's fine. I mean, it links into so many other things. It works, but still seems awkward to me. The actual title just seems a little awkward to me, but it links through the bill, so it's fine.
That is the.
Just for clarification, are we finished with No, are we finished with Mrs. Aldred? You're the sole voice. All right. Just for clarification, I noticed at G, it says a regional hospital or public health facility within the meaning of Section 2 of the National Health Services Act. Just for my information, does that cover University of the West Indies? Because, and the term regional here, is it regional in the local sense or regional in the Caribbean sense? Local sense, you're talking about like Sarah and okay, so right. So where would you put UE? Is UE deemed a public health facility?
UHWI, University
Right, UE Hospital, is it deemed a public health facility? And also like practical nurses, is that covered under the Nurses and Midwives Act? I have not had the benefit of reading that act, so I'm not sure.
And it also says
nurses as opposed to a nursing assistant
and our practical
University
nurses
Hospital
included.
of the West Indies.
What's the response? Okay.
UE has a special status, you know, so you need to make sure we haven't left them out. It's not managed by Sarah, you know. No. UE does not manage under the regional health system. Yeah.
Remember, whether they're public or private, they would still be covered. Whether they're public or private, they would be covered under the definition because they would fall under H, which is a private hospital or private health facility. Well, so which means they're straddle G and H.
The issue with G is the fact that it references a National Health Services Act, which set up the regional health system, and UE was not part of that system. So we just need to check to see that when we talk about a public health facility within that meaning, or a regional hospital, that UE is covered by it. That's all.
We think we found it. So public health. So public health, the first schedule says public health facilities are clinics, homes, drug windows, health centers, public hospitals. And then the second schedule, which speaks about the regional hospitals, speak to Kingston Public Hospital, Mandeville Hospital, St. Anne's Bay.
Sorry, perhaps you can read again, because you did mention something about Section 1. Ms. Wakim, Ms. Murray,
public hospital
if you could just read over what
is public hospital defined? No.
I think.
So what the Act says is that public health facility means any facility specified in the first schedule, right? And then going to the first schedule, it says clinics, right? Clinics, pharmacies, public hospitals, public psychiatric facilities, maternity homes, labs, health departments.
Okay.
And then the second schedule, they define the regional hospitals as what I would have mentioned before, which is the Kingston Public Hospital, Mandeville Hospital, St. Anne's Bay Hospital, and Herbert Eldemere Regional Hospital.
So is it clarified that UHII would be included, would be considered? Okay.
A response is being formulated. A response is being formulated.
In relation to the midwives and, well, we're waiting, the practical nurses. So the Nurses and Midwives Act defines, it governs mental nurses, it governs midwives, nurses, and then it has an assistant nurse, but the assistant nurse should have been admitted to the assistant nursing program authorized and duly recognized by the appropriate regulatory body. It may not cover the practical nurses who go to, you have these little 6-week courses. And I don't know that those practical nurses would be deemed assistant nurses unless they went to one of these regularized, authorized places.
So, Chair, to cover the University Hospital of the West Indies, we could add a paragraph K, which would state the hospital established pursuant to the University Hospital Act.
Can I ask a question? Have we settled on an understanding as to whether UE, though, is appropriately categorized in G or H before we move to create a K? It's not? It's a hybrid?
They're not sure it's properly captured.
Thank you very much.
So that would make it desirable then to specifically reference them just to make it clear that they are intended to be covered.
And are there any more hybrids that we need to
That's the practical nurses.
to worry about since we're discussing hybrids? Lone voice in the wind.
Lone voice. Lone voice is getting good support.
The several voices in the wind. Are there any more hybrids that we should concern ourselves with? UE is prominent, but is there anything else that you need to?
What about the practical nurses? Have you? What about the practical nurses?
Are we decided?
I'm going to say we caution against including as a health professional somebody who is only trained for 6 weeks and is not a part of a registered group that is monitored by one of these pieces of legislation. I mean, the extent to which personal data is shared with a practical nurse or sensitive personal data, we're assuming that, well, there could be a data controller in their own right as an individual. It doesn't mean that they're excluded from the legislation. They have their own. If they're a part of an organization, they will be captured by that organization. Okay, so let's step back. If they're working on their own, then they're still a data controller. If they're part of an organization, then it is the organization that collects the data for them, and it is the organization that is a data controller. So either way, they would be captured. If they're a sole practitioner, then they would have to abide by this because they would be collecting personal data and then also collecting sensitive personal data. But for the purposes of this piece of legislation, we're saying that you're not classified as a health professional because you don't fall within this definition. No, I mean, whether or not we'd want to include in this definition of health professionals someone that is trained for only 6 weeks and is unregulated,
but is
not advisable.
Is it a fact? Is it a fact though that the practical health nurses are unregulated? Because I know there are courses at maybe like Knox College that some of those colleges that do courses for practical nursing, not only the 6-week courses. So I think you need to.
Miss Murray, Through you, Madam Chair, Ms. Murray, if you could just please indulge me and just explain to me again the context within the health professional is referenced at section 24.
All right. So clause 22, which establishes the first standard, requires that the data controller processes data fairly and lawfully. And processing data fairly and lawfully would include how the data was obtained. It must be legally obtained, for example. But what clause 23 and 24 does is that it says, notwithstanding that the data controller is to process data lawfully and fairly, what that means is that consent should be given, for example, and in the case of sensitive data, express consent must be given for you to process. It makes an exception though. It says without consent, you can process that sensitive data if it would be for the if it's in the person's medical interest. And they're saying that the persons who can process without consent are professionals, health professionals, as defined within the legislation. Everyone else would need your consent to process your data. So that practical nurse that we're talking about could not process your data without your consent because they don't fall within the definition of a health professional. So consent would be required, and written consent is what would be required for them to process your data if you're a client or for the practical nurse. But the health professional, as is defined here, they could process for medical purposes your data without your consent because, of course, it's for vital interest and to save your life and so on.
Oh, Ms. Murray, they'd be still subject to all the standards, right? They'd be subject to all the standards. Okay. All right, so I take it the committee agrees with the definition of health professional and the inclusion of UHWI on item K as per the CPC, and the exclusion of practical nurses. Okay, no dissent. Right, no dissent. All right, let's move to health record. Let's see, yeah, health record. So health record means any record which is in the custody or control of a health professional in connection with the care of an individual. And it consists of information relating to 1, the past or present physical or mental health or condition of an individual, for example, clinical information about diagnosis and treatment, genetic data, information about the testing of any body part or bodily substance, or the donation of a bodily part or bodily substance, the registration of an individual for the provision of health services, and any number, symbol, or code assigned to uniquely identify the individual for those services, the name of the individual's healthcare provider or payments made by, or the eligibility of the individual for the provision of health services, or any other health-related information about the individual that is collected in the course of the provision of health services to that individual. So the ministry is in agreement with this and recommends no further amendment.
So it was accessible record, which was defined as including health record. And then health record is also referenced at clause 66 of the bill.
I take it the committee agrees with this definition of health record.
In the interpretation section, accessible records. Clause 2.
All right. No dissent? Oh, Senator Binns, you're still researching?
Right. So accessible record, in response to the member's question, is used in the definition of data and in conjunction with clause 39. And clause 39 treats with currently temporary exemption for manual data.
We can proceed, but I'm going to ask you to just allow me to return to this if needs be at a future sitting. Thanks. Because I want to understand why the ministry, Ms. Murray, is not in agreement with the proposal to include insurance companies, because I know for a fact that they conduct very extensive health checks and they have all the record, from your hair strand to your pupil to your DNA, they have everything even more than you may have. So yes, and I would know. so I want to understand the reason behind it, but I think I need to read the sections that references health record first.
So would you want an health insurance company to process your medical data without your consent, which is what
No,
this
I
is
don't.
given.
That's what I'm saying. I need to read the sections that references health record to fully understand, which is why I'm saying that I'll come back to this section at a future sitting after I have read.
All right. Good. Okay. So I'll put a square bracket around that for Senator Binns. All right. We'll move on to the definition of minor. Page 15 in the matrix, I think page 6 in the bill. A minor in relation to an individual means an individual under the age of 18 years old. So do we agree that a minor is any individual who is less than 18 years old?
I remember that a concern was raised earlier, I think, from Jamaica Aid Society about certain consequences which could flow from having this definition. And I think that in certain other pieces of legislation, there has been some concerns have been taken into account, and minor has been defined differently. There is in fact, if you'll just permit me, legislation which actually puts it at 16. And I wonder if this is, I can't remember the name of the legislation now. The law, exactly. Medical. And so I'm wondering if in this context we shouldn't have defined as 16.
But it says the law reform defines it as 18.
Recommendations section, this is page 15 of the MSET matrix.
Yes.
Right. In the analysis and recommendation section, they have captured here what are our views
So
in response.
You have it here as 17.
Right. No. Well, the bill at clause 5A1 says that consent by the minor. The rights of an individual who is a minor may be exercised by the minor in any case where the law recognizes the capacity of the minor to act in the matter to which the data relates. So that if there is some other legislation that says that a minor may consent to whatever it is that the legislation applies to, that specific legislation would take precedence over the general provision in the general rule that you need to be 18 to consent to the data protection bill. So it would mean in the specific case that Jamaica Aid Support presented, if a 17-year-old or 16-year-old consent would be governed by the law reform Age of Majority Act and not by the data protection bill in relation to the health record.
Yes, that would be satisfactory, I think.
Yes, I think that's in our view that's a full response to the concern that they had.
Out of interest, how does the European, the new one, how do they treat with this issue of who's a minor?
No. I think on this, I need to look back on. No.
Given how teenagers live on the internet.
They say it's based on the member country, and they allow member countries to go all the way down to 13, but not below 13. So
they go down to 13. I mean, I was just thinking, when a youngster is accessing an app or something and there's a consent button to be clicked, they can't, if they have to be 18 to do that. It just seems kind of inconsistent with the realities of life
but,
in this area.
Through the chair, Mr. Golden, I think the social media companies are more interested in a business decision rather than protecting the rights of the person.
True. True. So.
Okay, are we agreeing? What age are we agreeing on? 16? 16. The committee agrees on 16. Sweet 16. All right.
Sorry, what happens in relation to the approach of the European Union is to have a lower or allow for a lower age of consent in relation to a specific context, and that is in what they call information service providers, which the definition is to hand somewhere, which we can share with the committee. But the contemplation of it is that when it comes to online type services, and especially educational type services, I think the member states are allowed to go as low as 13 for consent, subject to some other contextual issues. So that lower age is in relation to that specific context and doesn't apply generally to all forms of consent to the processing of data by minors. So if you want to follow that approach, your consideration would be whether to also create a carve-out for online service providers or some other type of context while maintaining a general, the general approach that 18 is required for consent.
I am
not to change the definition here.
Chair, I am very wary of predicating my contemplation on what online service providers do, as their objective is more commercial than anything else. They are not interested in the protection of our children. No. They are interested in increasing the numbers of people who access their services so they can get their data, so they can sell more ads. So I'm I would want us to be very careful in looking at it from that perspective.
There are so many government agencies that collects data that now do so with the permission of adults, for especially those collecting data and for TRN and all those agencies. Now, as it is now, you have to be 18 and over before that person can go in and give the data. You must get the consent from the parents for data collection in terms of passport application, TRN, and all those things. So we need to take that into consideration while we contemplate this.
In terms of the age you're talking about, Mr. Witter? So the committee has generally agreed 16, but you're saying you're not in favor?
We're cautioning against the 16 because even with the GDPR, that age of 16 wasn't of general application. It was in a very narrow context. Yeah. If you change the definition here of minor, this will now be of general application. So it means wherever you're talking about a child, you're talking about someone 16. And that is not what they did in the GDPR. When they referred to 16 and even that lower age that could go to 13, it was in a very, very limited, specific context.
So committee, having heard that caution from AGC, are we going to reconsider?
Taken into account the caution from, in terms of what I thought that Senator Morgan was making another recommendation. I thought that we had gone with the original recommendation.
18? The original recommendation?
No, which was that it depended on how it was defined. Right. I need to have it cleared up then, because I thought that's where we left it until the intervention by Senator Morgan. So what is it that we are actually putting to the committee now?
I apologize. I made an intervention because I thought it was put to the committee that you change the definition of minor to mean person of 16, and I thought it was agreed. So that is why I made my intervention to say I would really caution against changing that definition to 16 to make 16 apply across the board.
You're correct.
I misunderstood. I thought we were going with the law reform, the legislation that depending on how it was defined in the legislation, then that is what we would use.
And then after that, something else was put. That was the reason, because that is in the law, and that would, so it means that even though you have the definition of minor being 18, this allows for any other law to prescribe a child being able to do something else under the age of 18.
Right.
One instance is
which is what we are approving, as I understand.
I think the chair, okay.
Okay, so now I'm clear.
Okay, so are we saying that the committee agrees with the 18 years? Which one of these recommendations? Because it speaks to the law reform at 18, then it goes on to talking about
Chair, if I might
parent
just
of a
say,
17-year-old.
if I might just say, what we were doing there was just responding to a comment that was made, and just to say, listen, we are allowed in specific pieces of legislation to prescribe what the age of majority is, or minor, or yes, I suppose either way. So this, we didn't recommend any change, and we're not recommending any change to the age. So it's right, 18.
All right, so I put it to the committee. The committee accepts the current definition of minor to be 18 years or younger. An individual under the age of 18 years. No dissent? Thank you. All right. We will jump over personal data based on the conversations, the discussions that happened earlier on, and the need for AGC and CPC and MSET to come back to us on that. Not sure if we should have the same treatment for sensitive personal data, or we go to that now. Sensitive personal data is going to be examined as well when we look at personal data? No? We'll treat it, okay, we'll treat it now. Okay. Committee, we're looking at the definition of sensitive personal data, which means personal data consisting of any of the following information in respect of a data subject: genetic data or biometric data, affiliation or racial or ethnic origin, political opinions, philosophical beliefs, religious beliefs, or other beliefs of a similar nature, membership in any trade union, physical or mental health or condition, sex life, the commission or alleged commission of any offense by the data subject, or any proceedings for any offense committed or alleged to have been committed by the data subject, the disposal of such proceedings, or the sentence of any court in such proceedings. I think the ministry has some recommendations as to changes here. Ms. Murray?
So the concerns, there are three concerns in relation to this specifically from the stakeholders. Let me probably go in order. There was an issue around sex life. There was a recommendation from Jamaica Aid Support that it be defined. There was also a concern around philosophical beliefs. That recommendation came from the U.S. Chamber of Commerce that it be deleted. And then there was a concern raised by the ALAI in relation to G, the commission of alleged commission of an offense. So those are the three areas. With respect to sex life, we're saying we don't think we need to define that. Nobody defines it. And with respect to philosophical beliefs, we didn't think that needed to be further defined or even deleted. The contention here being that your beliefs are your own, and those no data controller should be asking you really to share that, because that would be considered sensitive. That's your beliefs. And then on the matter of Well, we didn't think it would be difficult to define philosophical beliefs, because that could range from, yeah, and it would be given that would be just, yeah. And then on the issue of G, we had made a recommendation that G be modified to limit it to the alleged commission of an offense by the data subject or any proceedings for any offense alleged to have been committed by the data subject, rather than the actual commission, because then by then that if you are charged and there's proceedings around, and then that becomes public knowledge anyway, unless the records are expunged or something of the sort. So it wouldn't be something that you could be keeping secret. Maybe they allege an allegation, but not something that has gone through a full public hearing and a decision taken in relation to same.
All right, so the only modification that the ministry is recommending is to the alleged commission of any offense by the data subject or any proceedings for any offense alleged to have been committed by the data subject. It is recommended that that be modified in cases where a court has disposed of a matter and the decision and sentence of the court is no longer a private matter or one which requires special treatment in order to protect the constitutional rights of the alleged offender. So that's the only change that the ministry is recommending. I'm saying the only for sensitive personal data, the only change the ministry is recommending is to paragraph G, where it speaks to the alleged commission of any offense by the data subject or any proceedings for any offense alleged to have been committed by the data subject. The ministry is pointing out that in cases where the matter has been, if there's a matter in court, if it has been disposed of, right? So that's the only change. So does the committee accept this change for sensitive personal data?
So that was what we were asked to define. And we were saying that when you look across legislation, nobody defines sex life.
Mike, please. Senator, Mike.
I was asking, Madam Chair, I'm fine with the proposal, but I'm just wondering what is meant by sex life. Is it how often? Is it your preference? Your origin? Yeah.
That's why it's better to have.
I'm going to Google sex life. Just to be clear.
It's very broad, right, Ms. Murray? Whatever.
Sexual orientation is a much better and more suitable term.
Oh my gosh.
No, but that's very narrow.
In human
That's very narrow,
sexuality,
though.
a sex life is a sector of a person's day-to-day existence which may involve sexual activity or represent the absence of sexual activity. I said it may involve sexual activity or represent the absence of sexual activity. So it is not to be seen whether you're celibate or celibate.
Remember that we are saying that this should be included, sex life in its broadest sense, to be included as personal, sensitive personal data.
Yeah, but why would you want to know?
But that's why it's included as sensitive personal data, so it's protected.
Oh, well.
No, I get that.
So it is a frequency.
Sure what the term sex life means.
Or lack thereof. If the frequency is zero.
So whatever your definition is.
Whatever your number is.
That's why it's left vague and broad and included as sensitive personal data that is deserving of protection under this bill.
They say they don't want. That's why I say it's a sensitive personal data.
But why is it not easy at all?
Because if you go to say some doctors, for instance, might ask a particular medical question, and it might be written down that, you know, for the month of January, X, for the month of February, 3X. I'm saying the information might be there for psychologists, for gynecologists. Yes. So this information is sensitive data.
Right, so then the committee agrees then. Yeah. The committee agrees.
Yes.
Of course.
Yes,
okay,
yes,
let's move on. Right, so we agree in terms of sex life. Does the committee agree in terms of the modification for G? And all the ministry is saying here, if on the matter, in the case where there's a matter that has been disposed of by the court and is no longer a private matter, that this does not need any special protection. There's no dissent. All right. Mm-hmm. All right, so we move on to clause 3. Clause 3.1 speaks to application of the Act. Except as otherwise provided for in Section 62, this Act applies to a data controller in respect of any data only if the data controller is established in Jamaica or any place where Jamaican law applies by virtue of international public law, and the data are processed in the context of that establishment, or though not established in Jamaica, uses equipment in Jamaica for processing the data otherwise than for the purpose of transit through Jamaica. A data controller falling within subsection 1B shall appoint for the purposes of this Act a representative established in Jamaica. For the purposes of subsections 1 and 2, each of the following shall be treated as established in Jamaica. A, an individual who is ordinarily resident in Jamaica. B, a body incorporated under the laws of Jamaica. C, a partnership or other unincorporated association formed under the laws of Jamaica. And D, any person who does not fall within paragraph A, B, or C, but who maintains in Jamaica an office, branch, or agency through which the person carries on any activity or a regular practice.
So, Chair, through you, members will recall that the issue around, the concerns around this particular clause was that, right, there are recommendations that it has be given extraterritorial effect because it seemed to be focused entirely on data controllers who are located here, or if they're not located here or established here, they're processing here. So essentially what the ministry is saying is that if the committee is minded to extend the reach of the legislation, and I think well, I know AG had provided some guidance in relation to this. It essentially, to say it's really up to the committee for us to decide, or us then the ministry, but the committee now to decide if it wants to go that direction. And we're saying if it is that you're minded to go in that direction, then we could look at Article 3 of the GDPR, and we've set that out, omitting one particular article, as something that we could look at in terms of language that could be included. That would go a little bit wider than what we have here now.
Through the chair, question. How does, and this is just from my knowledge, because I would admit that I am not as informed as I want to be, making it extraterritorial, wouldn't that require the person who you're imposing the responsibility on to have agreements with Jamaica? Yeah. So then how can we as a committee impose that obligation on persons who have no legal obligation to enforce Jamaican law within their territory?
So, in the bill, there is provision. There is Clause 62, which provides for a sort of international cooperation arrangement regarding the enforcement of data protection provisions. What we have noted in our research is that although you may have, for example, in the GDPR, this provision that you're targeting people who are outside, but there are persons in the union that you're collecting data from. The issue that they have had in terms of enforcement is in relation to outside. So what it boils down to is how you can get that level of international cooperation to enforce the provisions of your own legislation. But what we are saying is that it's no harm to have an added element of extraterritoriality in Clause 3, but it also has to be construed within the context of Clause 62, that in order for this to work, you would have to proceed on the basis of Clause 62, which is the minister's power to enter into negotiations with a view to exchange of information with other data protection authorities.
A recent case in court. There was a recent case in court relative to some data protection issues.
You mean
sometime earlier this week?
You mean the one about?
We had somebody pleaded guilty.
That wasn't it.
Huh?
That wasn't data.
It wasn't. I'm just asking if it was about overseas jurisdiction from the United States.
My own view is to accept the recommendation of the committee that we put it in and work through, because one of the things that some persons who are looking at the Data Protection Act, this bill, feel is that it's already so far behind. And I think this would give us an opportunity to perhaps, anticipate the future, to give the possibility of using the treaties and so on to be able to bring it into force. At this point in time, I don't see how, it could be enforced, but I think that since we're contemplating that several aspects of it will come into effect over a period of time, this is perhaps something that will make the bill more relevant for the future.
Sorry, Chair. Also, just to make the point that, and CTD had raised it earlier, that in a number of jurisdictions that are non-EU based, in order for them to have that interface with those territories, there is a sort of adequacy assessment that is undertaken by the EU. So if we do not have a provision which allows for enforcement outside of EU territories, that could be a factor that would be inimical to us going forward in interfacing with EU member states.
So, Chair, essentially, and that was our recommendation, we were saying that given the reach of the GDPR, it is anticipated that other countries would be following suit. So you're going to see these kinds of amendments happening and extraterritorial territoriality being extended too. So.
Committee is in agreement with the recommendations of the ministry on clause 3. Clause 3.
Is this a convenient place at which we could pause until the next occasion? It is almost 5 o'clock. Normally we go like 4:30.
Okay, it sounds as if I will be outvoted.
Chair, let the committee know it's because you're the Minister of Energy while you are pushing forward.
We will start again. When we begin the next session, it will be on the Information Commissioner, Clause 4. Yes. Page 10 of the bill. Page 26 of the matrix. 26, yeah. 26 of the matrix. So I want to thank you all for the robust debate, for the contribution this afternoon. Let me say, we are scheduled to have another session next Wednesday, but yesterday it was announced in Parliament that there will be Parliament next Wednesday at 2. So I'm asking the committee to meet in the morning at 10 o'clock.
Have you checked with the other to see if there's any other committee?
No, they've said it's clear.
Okay.
All right, so we meet again next Wednesday at 10 a.m. to continue our clause by clause of the Data Protection Bill, starting with the Information Commissioner, Clause 4. Thank you. Thank you to our able team, to the parliamentary personnel, staff, to my colleague, MPs and senators. Thank you so much. See you next week. Meeting is adjourned.
You know, this inflation thing is a really big deal. It affects everything. Inflation determines what your money can do. So whether you're running the government, running a business, or running your household, you can't plan properly or plan for long unless inflation is low, stable, and predictable. We need a little inflation to encourage production and growth. But inflation is like your blood pressure. Can't be too high, can't be too low. Inflation is the real heartbeat of the economy.
Consumers and investors feel secure.
These videos are intended to be used to complement the instruction of this subject by classroom teachers as a teaching aid.